Well, we know what they did to you. We can't see it all. We can see it all. And their lies, the lies they laid on you, we don't believe it all. We don't believe it all.
It's a new one from Stacy, everybody.
Although
just noticed it when I got home and listened to it. I love it.
Exposed by their ringing hands, the excuses that they speak. And we see what they took from you. They didn't take you all. They couldn't take you all. And we see what the future holds for you. Yeah, we can see it all. We can see it all. Doors are gonna open for you. Our hearts and arms, oh, they're open too. Know the reasons we may never find. Soon this nightmare, it'll be left behind. And we see the damage done to you. Yeah, we can see it all. We can see it all. And we know there's goodness left in you. I can hear it in your voice when you call. I said those doors are gonna open for you. Our hearts and arms, oh, they're open too. Though the true reasons are now we may never find.
Welcome, everybody.
So this nightmare, oh, well, it'll be left behind. And we know what they took from you, but they couldn't take you all. They didn't take you all.
All righty. Hello, everybody. How you doing? Let's stop that. Here I am. Hello, everybody. How you doing today? So we're here today with Travis. Obviously, we're going to be talking a little bit about the state's response, of course, to Kathleen Zellner's motion for remand, obviously, because the bones in question that she wanted to test have, in fact, been given back to the hall box, and that stuff is supposed to have been held on to, and if it was gotten rid of, it then there was supposed to be some correspondence to Stephen or his counsel informing them that was going on, which didn't. And so, that's what's all going on here. That's the argument at stake. And we're going to talk about some of the things today going on here. And we're going to go ahead and address maybe a couple of other little issues around the appeal that some of the people may perceive, but we're going to talk about it and we're going to see if we can't dispel that a little bit. So obviously starting out today, we are, going to talk about, I thought it was interesting that the motion was really not very inspired is really the word that I'm coming up with. It just doesn't.
You mean the response?
The response, yeah, that's what I meant.
Yeah, the response. Okay,
the response to the motion. The state's response just seems very uninspired. And after talking to Travis, it kind of reaffirms the feelings I was having, but I'll let Travis talk about some of those things. Namely that this is the same, the claim she would make for these bones is filed under the same exact statute, which is, was it 97406?
Yes, sir.
Yep. So 97406. So this is essentially the same type of thing. It's the same thing. It doesn't like exactly connect to anything she's already argued, but the fact of the matter is you would file it under the same statute. And we're going to talk about something that Travis calls judicial efficiency and things like that. So let's go ahead and look at what we got here in the comments a little bit. Let's see if there's any questions or anything. Or hello, everybody. Hello.
Hi, everybody. Hello.
So John Smith says Steve needs to follow procedure. So that's that's people getting frustrated with Kathleen filing motions like this that I guess they seem to perceive that it's just delaying the appeal. I think that's what that comment is. I personally think that this just became known to her. This is the reason why I think it matters now. And it's good she's making the appeals court rule on it, because she just discovered this right now, just literally just, days ago. Okay. If she just sits on it and goes, okay, well, they're just going to deny me, and she doesn't say a word, then later on down the line, then they can try to argue, well, you knew about this back then. Why didn't you say anything? So I'm actually glad that she's saying something now, because that means she's dealing with it in a timely manner and nobody can try to bar her later on that claim. So, and if the court denies it, the appeal moves forward, and then she files it after. You know what? That's fine. But we're going to talk about whether or not that's efficient. Okay? Is it really efficient to do it that way? And whether or not it should be kind of brought in and, melded into the current appeal, because as I was just saying, it's under the same statute that of the appeal that they're on right now. It's the same exact 97406. Okay. So that seems to me that these are compatible. This should all just go together. And then if they do that, it ends up saving lots. Look at how long this appeal is taken. Can you imagine a second one? Right? If you think about that, can you imagine another whole second one after? No, she wants to do this now for the reasons I'm saying. Number one, she's dealing with it in a timely manner. Nobody can deny that she was trying to do that in the first place. And number two, I think her approach is, as Travis will probably talk about at some point, is more judicially efficient, and will bring these things to a close quicker and quit bogging down the court, in a sense. So, at the open, anything you would like to say about the motion, Travis, in particular?
No, let's dig into it. It's interesting. People that are pro Stephen Avery are getting frustrated by the number of motions. That's interesting. It's a good thing for Stephen. Kathleen Zellner doesn't do this for her health. I mean, there's reasons for this stuff. The primary goal is get Stephen Avery out of jail.
Right.
Anybody seen anything contrary to that, please let me know. I haven't, but
Right.
I understand people can get frustrated, but this stuff isn't being done for the entertainment of the public. This is to get Stephen Avery out of prison.
This is not NFL Super
from a life sentence without the possibility of parole. Think about that for a minute. Being in a cage for the rest of your life.
Right.
A month here, a month there. To get this stuff out to the public, it's not what she's about. But we'll go into this. But I can understand people's frustration. But
sure,
put this into context. I'm a big believer in context. What is the context of this? This is her lawyer filing stuff on his behalf to get him out of prison where he will surely die if she does not succeed.
Right. Absolutely. So a lot of people, so somebody says here, John Smith is saying she's doing it for the publicity. So like I said,
can't help you there, John.
Yeah, exactly. It's like I said, if she had decided not to file this or not to say anything about it.
She's got 20 exonerations based on the publicity.
Exactly.
Gosh, publicity
and you know what? Anybody that wants to criticize KZ for using the media against the state and wants to be mad at her or say cry foul about that, well, you know what? The genie was let out of the bottle when Kratz held his little press conference and he used the media the way he did and completely tainted the entire state of Wisconsin. Okay, at that time. So the state has used the media in multiple ways as well.
Good point. Great point. 99% of the people on your channel and on all the other platforms would have never heard of this case without publicity, without, MAM1. It was same in West Memphis 3. These cases happen all the time, all over the U.S. Fortunately for Stephen and Brendan, this picked up, a documentary crew, just like West Memphis 3 did, just like a lot of other cases do. And publicity is what got this thing on the radar. Publicity is what got Kathleen Zellner interested in the case. So, you can't have it both ways. You can't have the prosecutor doing his publicity stunt, his little 2-ring circus, totally pollute and taint the jury pool, end up with this atrocious verdict, this miscarriage of justice, and then not expect Kathleen Zellner to punch back. She punched back today. Yeah. She got their response and she tweeted. But everybody tweets now. They were saying that about the current administration. Oh, this guy tweets. They were saying about the last administration, but people tweet now. I don't like it. It's not my style of litigating, but
look, I never liked Twitter until I got involved in this stuff, so I get it. But, I use it now. It's a tool.
Yeah, but people tweet. I can't really go with that.
Now, does the commander in chief tweet too much and should maybe stop?
I'm not getting in politics, but
I know.
I'm just using that as an example.
I know what you mean.
Everybody tweets now, except me. Apparently, I'm a dinosaur.
But moderation is a great thing in the world. So, anyways, moving on.
Falcon had a good question. What happens tomorrow? Because it's February 1st. Nothing, Falcon. The motion is an automatic stay. Her brief will not become due until the court rules on the motion.
And then they will give her another due date.
Yes.
Which will not be far off. Might be a month, though. Might be less.
No. The minimum would be the number of times. The minimum would be the number of days that the motion has been pending. So that could be under, just at a week.
Okay.
They could give her another 30 days like they did last time, or 14, or whatever it is.
Right.
Good question. Falcon.
Let's see. Is there a time frame when the decision could come back from the court in regards to the bones being given back to the Hallback? So, yeah, you can, I think, pretty much expect it any day. Well, actually, Travis, we were talking about that. You want to go ahead and expound on that?
Well, last time we had this go around in December, she filed her motion on the 17th. They responded. The state responded before the deadline. You have 11 days to file a response, but they filed it little bit early, and the court issued their decision the same day that the state filed their response. Very quick, very quick turnaround.
Right.
So, I'm figuring 1 to 3 days, but let me tell you all about this, especially if people are getting anxious about the number of motions and the waiting time. The longer this takes for the court to decide, the better it is for Stephen Avery. It doesn't take very long for a court to deny a motion. Very little time. It takes a long time for a court to grant a motion like this.
So the longer it takes, the better.
The better. So you can have a decision tomorrow morning, 8 a.m., denial, or, you can wait a couple of days and get one that says granted, and, under these terms, and this is what we want the circuit court to do, by when, et cetera, et cetera.
Can they actually order the circuit court to have a hearing?
Sure.
Are they able to do that?
Oh, yeah. They can set forth what issues they want the circuit court to develop factually. They can tell the circuit court, we want factual findings and conclusions of law on these issues.
Okay.
Whether the evidence preservation statute was violated, whether, Wisconsin's form of Youngblood is Greenwald. We'll get in that in a second, but want to know what happened to these bones.
Right.
We want they can be super specific about it. They can be general about it. And if you want to see what they can do, how they can do it, so they can order the evidentiary hearing. What happened with the computer records is they just remanded it back to the circuit court to deal with. It was up to her. So the motion was filed. The judge considered it without a hearing and denied it without a hearing. Which is what
I'm about to get at, which is they got to realize at this point that that court is just not going to give Stephen or Zellner any play. They got to realize that at this point, I would think, right? Judge Angie certainly isn't.
Well, yeah. I mean, it's not lost on
because she's not even reading the shit. Or, well, she may be reading some of it, but she's like skimming it and saying no. Right?
Yeah, there hasn't been a lot of analysis from the prior decisions from the circuit court thus far. So I'm just left to assume it's because of limitations, because it's not from a lack of briefing, but no real legal analysis.
So Falcon says the state still has most of the bones, apparently.
Most isn't good enough.
Yeah, and especially if, I got to imagine they weren't given the more questionable bones.
Preservation statute doesn't say, keep most of them. Assuming it applies, just keep it all unless you give notice. Youngblood and Trombetta, which form Greenwald in Wisconsin. If it's a violation, either from the Trombetta standard, it's material. It doesn't say, well, hang on to most of them. If it's a bad faith destruction, it's either bad faith or it isn't. It's either a constitutional violation or it's not. It doesn't. If she can show the materiality and the significance and the intentionality of the destruction, then doesn't matter if it's.
Yeah, but basically,
they have 99% of them. If there's one bone that's inculpatory of somebody else, or can exculpate Stephen, and it was under either standard, it's a constitutional violation. It's a new trial.
Yeah, and I got to imagine. I mean, I got to imagine the bones that were actually given back are most likely the bones that were going to give us a positive ID of Teresa Halbach. And that's why I think it's important that, because you got to understand, they went in there into these bone piles, into these, evidence bags of bone piles. And they weren't trying to pick out bones that they were really questioning whether or not they were human. They were probably going in there and getting the ones that they really figured most likely were. And I would think those would be the bones that Kathleen Zellner's most interested in, because they're most likely going to be Teresa's. So it's most likely the bones that would have tested positive for Teresa have been given back. And that's really a big part of the issue, I think. So
Yeah.
yes, but the fact that even one or two of them were given back is wrong according to the statute, which is the point Travis is trying to make, and that's an important point.
But to flip it around, so let's say this evidence was the 13 pubic hairs in Stephen's first case that ultimately exonerated him. And let's say they accidentally destroyed half of them, but they were still able to test, and it came back. There's no harm, no foul. But if they've got photographs of 13 pubic hairs, and they, one or two of them have root balls on them, which is what you need. You can't just have a hair; it's got no DNA in it.
Right, it has to have that root.
But, there's
a little bit of flesh that gets torn off with the hair.
Right, two clear as day photos with two root balls, and you can show this stuff wasn't preserved pursuant to the statute, and they weren't given notice, or it was destroyed maliciously or intentionally. It's up in the air right now what would happen if there's a violation of the preservation statute.
It's funny because I named this video, "The state doesn't dare explain their actions," because that is one thing in this response that they do not do. They do not attempt to explain what they did.
Yeah.
They refer to it once in the motion, but they don't try to explain it at all.
Let's start going through it, and then people can chew on some of this stuff that we've started out with, and then we can kind of just go through this in order, and then people kind of think through this stuff, because we're getting ahead of ourselves a little bit, but I'm happy to do whatever you want to do, Erekose, but I thought maybe we'd just start digging through this and then finish up with some of these other things. But
all righty, folks. This is the state's response.
So that's the first page there. All I had to comment on is their introduction is exactly what an introduction is. They're going to tell you what they're going to tell you. They start right off saying they oppose the motion. The other option could have been, we join in Zellner's motion to stay in remand. We want to know what these bones are too. That was an option, but they obviously didn't go that way, and nobody expected them to.
Exactly. Not in Wisconsin, at least not in this area of Wisconsin. So they're basically stating what they're looking to do. Let's see here.
So that's, it continues, that second paragraph continues onto the page. Scroll up a little bit towards the top. There you go. That's perfect. So what, they're pointing out here, she's got a 97406 motion, which is a post-conviction motion. And so the way these things are designed is they want you to bring these things, they want you to bring all of your claims in one 97406 motion.
That's the normal way, folks. That's the way like it's supposed to be, right?
Yeah, okay. They want you, because if you don't bring up a claim that you should have been,
because it's efficient.
you're what they call procedurally barred. If you should have brought something up at the time that the motion got submitted to the district court or the appellate court, and you didn't bring it up, you're barred. So we'll get into why that makes it ridiculous, this offer. Well, you can dismiss this appeal and go forward with your bone testing. I mean, it's just utterly, ridiculous. But,
right.
So she's got a 97406, and, we're at the top of page 2, right where you're at there. The issue Avery claims he would like to pursue is a new, and they'll keep repeating this, a new Wisconsin Section 97406 motion. A new motion. They keep saying that. New motion. New motion. So,
they get really repetitive. I noticed that.
So then the middle paragraph there, which is the third paragraph of this introduction, it made a prior request for DNA testing, which was, of course, denied. That's talking about it in December. But they also remanded this case, the circuit court, to allow Avery to develop an entirely new constitutional claim related to the DNA testing. So they're talking about, new claim. Okay, the next paragraph, unless you had anything on those.
Just wanting to point out for the theme of this is the fact that 97406s are meant to go together. So it's not so far out that Kathleen Zellner is trying to merge this in, because due to judicial efficiency, it's actually the thing that makes sense. Okay, let's move on.
Okay, so that bottom paragraph, let's see. Staying this appeal, they claim, and remanding for the litigation of such a motion would result in unnecessary delay.
Right.
And litigation.
Mm-hmm.
Unnecessary delay. As noted previously, this appeal has been languishing for over a year. Who's been languishing?
Yeah.
Only one guy I know been languishing. Two guys, but one guy in this appeal has been languishing.
Right.
Does it interrupt the AG's office Starbucks time or what? I mean, what do they care? Doesn't matter to them to let the court decide this. Now, then they start this ridiculous thing that they're going to repeat over and over. If Avery no longer wishes to challenge the denial of his previous motions, but instead litigate an entirely new 97406 motion, he can voluntarily dismiss this appeal and pursue the action.
Right.
So it's like, dismiss that appeal with all of those ineffective assistance of counsel claims, with all of those prosecutorial misconduct claims, with all of those investigation irregularities that were talked about by the former FBI agent,
Greg McCrary.
Right. To give up, the ineffective assistance of counsel claims, to give up all that she's done to undermine the confidence of the verdict. Yeah, we're going to go ahead and we're going to, give all of that up, be procedurally barred from ever raising it again in order to determine whether the state violated yet another constitutional right.
One thing.
Yeah.
Yeah. You're going to let go of a basket for an apple.
And as we go through here, let's see how many times the state mentions, satisfies the court about the facts regarding returning the bones to Teresa. Let's keep a tally of that. I haven't seen it yet. keep talking about a new claim.
Right.
They talk about that, but
well, could it be that what they're trying to do is almost like if they're trying to suggest, like they're trying to maintain these things should be done separately, even though really, because they're the same statute, 97406, they really should go together due to judicial efficiency, right? Then
well,
does it seem like
that's
they're
what
wanting,
Zellner argued in her brief, that it
right?
makes sense for purposes of judicial economy,
Right, economy. There you go. So
which is judicial efficiency.
right,
Let's save some time and hassle.
right.
But we'll get into this in a second. But no, what they're done is,
Well, I'm just saying, does
they
it seem like them separating those, just trying to keep
no,
that separate
no,
and
no,
forcing Zellner to go for
no.
All right.
Just make this simple. December, they filed this motion, basically the same thing, and because in December they were asking for Zellner was asking for an apple, and they filed this opposition, which basically reads the same way, and it worked. It got denied in a day.
Right.
And so now come January, Zellner files a motion asking for an orange. And, they go, oh, well, this worked last time with the apple. Let's try it with the orange. That's all it is. And, we'll see this because we go through this. How many times do they mention, oh, no, those bones were never returned. We still have those bones. How many times they talk about the bones in this motion? And how many times do they talk about the evidence preservation statute? And we'll go through this and we'll keep a tally.
Okay.
But no, I don't think they think it should be separate. I think I don't think I would do that much different. I would have repeated everything in my response in December, but it's a different motion. I would have gone a little bit beyond what they've done, well beyond what they've done, because as we go through this, I don't think they've covered it. But did you have anything else? And we'll start on the background, or?
Nope. Yeah.
Okay, background. So this is bottom of page 3 of the response, and we're not going to go through this, detail.
Right.
That first paragraph, they talk about the conviction for murder,
right,
and possession of firearm by a felon.
Right.
Go down to the next page. In June of 2017, that's the motion that she filed after her motion for additional testing.
The one we're reviewing right now.
Yes. She filed her 97406, alleging a multitude of constitutional errors. Okay, keep that in mind. Multitude of constitutional errors. That's the basis of her motion. The circuit court denied his motion without a hearing on October 3rd. He filed a motion to reconsider and several supplements, which were denied. On November 28th, 2017, Avery filed a notice of appeal from the circuit court's final written order on November 30, 2017. Okay, the next paragraph, on June 7, 2018. Now, this is a big win for Zellner. Big win. On which, they've got to throw in here, because you start leaving out pertinent facts in an appellate court, you can get in big trouble in a hurry. So they point out on June 7, 2018, this court retained jurisdiction, but remanded this case to the circuit court to allow Avery to file a supplemental 97406 motion to litigate Brady v. Maryland claim. It was a new Brady claim, just like this is a new Youngblood claim. It was a new Brady claim based on the late delivered disc, is what it was called.
Yes, the CD.
Yep, the circuit court denied that motion without a hearing as well, and the record was transmitted back to the court on September 25th, 2018. What's significant about when the record was transferred back to the court is that started the time for her brief to become due. She requested an extension, and it became due in December, late December.
Right.
So she has won. She has filed for a motion and remand and stay. Got denied by the circuit court. Got up to the Court of Appeals. Court of Appeals said, no, this makes more sense. Even though it's a new Brady claim with the computer stuff, this just makes more sense to have the circuit court handle it, figure it out. It's not going to delay things too long. It delayed it from June until
December.
September. Because it's got so June, July, August, September, 3 months, 90 days. It delayed it, but now that appeal is consolidated. The issue about the Brady is consolidated with all of the other issues that are up on appeal of the denial of this 97406 motion.
Mm-hmm.
The earth didn't open up and swallow anybody. The AG's office was able to go on and do what it needed to do. The criminal justice system didn't come to a grinding halt. More information was developed for the appellate court to hopefully make an informed and reasonable decision. So next paragraph. On December 17th, 2018, Avery filed a petition to stay this appeal and remand the case to circuit court for post-conviction DNA testing of bone fragments. Now, these happen to be the same bone fragments that are portions of the bone fragments she wanted to test happen to be the same subject of motion that's pending and that we're looking at the response to.
Mm-hmm.
So, but make no mistake, she was asking to post for other bones besides these bones that were apparently returned to the Hall box. They included the bones that they wanted to test. And on December 28th, the court denied, going to the next page, the petition stating that, this is very important here, stating that, quote, the scope of this appeal is limited to a review of the circuit court's orders denying 97406 motions, and therefore good cause to remand has not been shown. Okay. So what are they saying here? There is a rule that allows any party, the state or a defendant, to stay and remand a case if you can show good cause. And so that's the only question. Is there good cause? It's
Right.
it's not a new claim rule.
Okay.
There's a new evidence rule that says if you've had your 97406 post-conviction petition heard and you're saying, oh, I discovered new evidence, there's pubic hairs. Putting aside the DNA testing for a minute, you have to show the court why you didn't know about that evidence. And if you can't show the court why you knew about that evidence, you're procedurally,
Why you didn't know?
Yep, you are procedurally barred.
Right.
So there's new evidence, but there's no rule that you cannot stay and remand a new constitutional claim. If it makes sense, if it's efficient, if it's not going to greatly delay the matter, that may that may constitute good cause. As a matter of fact, it has. Tracy found, but unfortunately, it's a per curiam case. Tracy found a case today. She quoted for me. She's already used this in her video, but Tracy's a researching mad woman. Gladney filed a motion for post-conviction relief in 2009, raising his current ineffective assistance of counsel claims. The circuit court denied the motion and Gladney filed this appeal. While this appeal was pending, Gladney moved for remand to the circuit court on the grounds of newly discovered evidence to facilitate the consideration of Gladney's claims together. Let me repeat that. To facilitate the consideration of all of Gladney's claims together, we granted motion to remand. And guess what? The earth didn't open up and swallow people. The criminal justice system didn't come to a grinding halt. I don't know exactly how much time it added to the appeal for the remand, but they remanded it. They had got their hearing, they got the evidence, and then it went. The circuit court did not grant the motion for new trial, and so it came up for the appellate court to look at. But the big difference now is that now they have everything to look at. They have everything to consider. Why on earth would you want to do motions? Okay, let's do ineffective assistance of counsel. See how that works. Oh, denied. Okay, let's do prosecutorial misconduct. Oop, denied. How frustrated do you think people would be with that?
Yeah.
2-year appeals. Okay, IAC didn't work. Let's do undermine confidence of the verdict. Okay, yeah. 2 years. No, the motion was designed. You bring everything at one time. Okay, enough about that.
Great.
You have anything to add before we move on?
Yeah, that's basically to hammer that home. It makes more sense to include the 97406s together than it does to do what the state's saying, to have file a completely new petition after this appeal is over with and stuff like they're saying. That's just going to take more time and it's less efficient. So their suggestions otherwise are rather ridiculous. So.
Okay, then they end their factual section with this paragraph on January 25th, 2019, which brings us up to this motion. A week before his initial brief was due, Avery filed another motion. Oh my God, to stay this appeal and remand the case. This time he seeks to pursue a new claim that the state violated his due process rights. Of course, he's got multiple claims that they violated his due process rights in that original 97406 motion.
Right.
But it's a new claim. It's oh my God. But that's not the rule. The rule is anybody can file it, and if you can show good cause. We just read it's a per curiam case, so neither side can cite it under the rules of Wisconsin law. But we know in Gladney's situation, that court, which was, I believe Tracy told me it's the first district. No, what do they call them there? Yeah, first district court of appeals, which is out of Milwaukee, I believe is what she told me. They agreed, yeah, this makes no sense whatsoever. Of course, now, so how many times in the factual section so far did we hear them talk about bones?
Once.
And I think they mention it just in passing in general,
yes,
right?
Right. Try to go past it as quick as possible while still mentioning it.
How many times did they mention that, she spent half her motion on The preservation statute.
Yeah, no mention.
Zero. Okay, all right.
Goose egg.
Yeah. So, yep. So these are not new. Not bringing constitutional claims, violations up for the first time. You know, we haven't even put a dent. We haven't even started with ineffective assistance of counsel. I think we're up to 50 something slides. We're, you know, about halfway through just that section.
A third of the way. A third of the way.
You know, I mean, ooh, boy, I can't wait to start that. Yeah.
But I did just get a preliminary preview of the slideshow today. It's looking pretty good. Yeah, that's looking pretty sweet. Anyways.
Right. So, all right. So relevant law. Avery is permitted to petition this court for remand to the circuit court for action upon specific issues pursuant to 808.0755. So they acknowledge he can file motions for remand to the court. The decision to remand is left to this court's discretion. That means it's up to the court.
Mm-hmm.
It's not up to the timetable of the attorney general. The only person they look at is the defendant. Can they show good cause why we would want to look at all of this together? You all can go back and look at Zellner's motion, but one of the things she mentions is judicial economy. Makes common sense, makes sense
right.
to do this at the same time.
Yes.
But they're acknowledging the decision is up to the court's discretion.
Right.
They even point out, for those using the word may in respect to this court's authority to remand. Shall is mandatory, may is discretionary.
Right.
And made a note here. Don't know how I was going to put this in, but they're miffed that she keeps coming back at them. But, you know, as we go through this, recall how whose fault is this that it's coming up a week before? They never supplement queso. They never tell anybody. So this was pre-Zellner.
Mm-hmm.
It's part of Stephen's first direct appeal. He's got court-appointed appellate counsel. His appeal's not even over yet. And they decide to have a bone giveaway. Not tell anybody.
Right.
You know, like under the secret of night, slip this stuff out the back door and, you know, nobody will notice.
Mm-hmm.
I'm sure that's not the way it was. I'm sure that I'm not sure of anything anymore. That's what I'm sure of.
Hey.
So
I know it's all so. Whew,
oh boy,
mind numbing sometimes.
Yeah. Anybody else? Okay, let's start the argument. So, you know, the law is clear. Anybody can ask for a remand. There's no limit how many times you can ask. You know, you can't repeat the same thing over and over again. But she asked for an apple in December. She's asking for an orange in January. Okay,
Right.
Argument. Once this case remand a circuit court so he can litigate a what? A new 97406 motion. A footnote say, well, it doesn't explicitly state this. However, the only procedural mechanism for raising a constitutional due process claim now that this direct appeal, and it's not, that his direct appeal has concluded would be a Wisconsin 97406 motion.
And as Travis said, There's nothing barring it because it's new. There's no law or statute barring new. New is irrelevant, essentially. So go ahead.
Right. Completely irrelevant. But they're confused because the new DNA testing worked for them back in December. Okay. The claim Avery wishes to raise is that the state violated his constitutional right to due process of law. We're talking about the new claim. The claim Avery wishes to raise is that the state violated his constitutional right to due process of law. What's the motion about that's under appeal?
Right.
Nothing but
right. Many
violations of constitution.
Sort.
Yeah,
right.
It's all violations of his constitutional rights to due process of law under the 14th Amendment. And to the extent it applies the Constitution of the state of Wisconsin. So if you read it broadly, this isn't even new.
Mm-hmm.
But the law regarding remand doesn't require or doesn't prohibit a new claim. It just says it's up to the court what makes sense to the court, and if you can show good cause for the court to do it.
Yeah.
Pursuant to Arizona v. Youngblood, by releasing a portion of possible human bone fragments to the Hallback family for burial in 2011. So they're restating.
So they're now actually questioning whether or not they're Teresa's bones, even though they gave them.
No. They're just repeating what Zellner has in her motion.
Oh, I see. Okay.
Avery wishes to raise is constitutional right of due process of law pursuant to Arizona v. Youngblood, which she cited, Zellner did, by releasing a portion of possible bone fragments to the Hallbach family.
Okay.
So that was laid out in Zellner's motion.
Right. They're just restating her motion.
They're just restating it. So, of course, they don't even mention the preservation statute. This claim is just as far afield from the issues in this appeal as the claim underlying Avery's previous request for remand, post-conviction DNA testing.
Right.
Far afield. Okay, so they say it's far afield. Next paragraph, towards the bottom of page 6, as before, Avery's motion does not identify specific issues related to the 97406 motions that are under review in this appeal. Because it's not, because the state hid this or didn't, reveal that they had done this. They didn't supplement the CASO report. Typically, from what I've seen, I can't say 100% sure, but I would think Brady requires a continuing duty to supplement. No question about that. They're under continuing duty to supplement. Avery admits that this is a new issue that counsel purportedly, quote, uncovered, unquote. They won't talk about the facts. They don't have the balls to say, we don't believe it, or purportedly is not a negative term, just means it's what the other side says, but they quote her word,
uncovered.
But you'll never see in the rest of this motion, we haven't seen it yet, where they'll even offer up the simplest of explanation.
Right. Oh, absolutely.
What happened to these bones? We're now on the next page, top of 7, in seeking remand because he does not want to waive this issue by not addressing it at this time. Non-waiver. You're absolutely right. She had to file this motion. She couldn't chance, taking it at face value, and no one has shown me that she is not credible in her account of either the need for new DNA testing in the December motion, or uncovering this attempted state cover-up. No one has shown me anything that, and least of all the state in this so-called response, that that's the biggest shot they can take at Zellner's credibility and veracity about what occurred. But she had to file this motion or it's waived.
Right.
And, I apologize for Stephen supporters if they're frustrated having to wait. How frustrated would you be if she didn't file this motion
and lost it?
Didn't preserve this issue?
Yeah.
Lost this appeal, went back and tried to test these bones, and they said, "No, we're sorry.
You should have said something earlier.
You should have said something earlier about it." How frustrated do you think y'all would be there?
Right.
I don't know. I just
right.
don't understand. I'm frustrated. I'm frustrated with that viewpoint, I guess.
Right.
Okay, next paragraph.
But, but at least we're helping people understand why it has to be this way.
That's true.
That's true. So that's the important part. So.
That's true. Good point. Okay, keep me in focus. Keep me on track. All right, next paragraph. However, a 97406 motion may be made at any time. Yep, that's what we're doing.
Anytime.
Making it January, right? Asking for an orange. And if the court finds a ground for relief asserted, which for sufficient reason was not asserted in a previous motion, the new motion is not subject to the procedural bar. So they're basically saying, "Oh, you didn't have to worry. There wouldn't be a bar." That applies. They want these motions to happen only once, and with the exception of newly discovered evidence, they'd be forced into she'd be forced in a situation. Well, this is why I didn't bring it up. So they can't do that to her now on the DNA testing in December,
right.
And they're not going to be able to do it to her now. Even if she loses this motion, she wins. All right.
Yes.
Exactly. That's a Tracy mannerism I picked up on.
Yeah, that was one of the first things I said when we first covered it. So.
Even if she loses, she wins this.
Yeah, because she's now set this up so this can go after this appeal if need be, or it can get absorbed into this one. However it ends up going. But yeah, so basically it ensures this issue will get argued, and that's the important thing.
So at first, there's not going to be a bar if you find ground for a relief with reason for not asserting it previously. Then the next paragraph, they say, won't be barred if he cannot establish a sufficient reason for failing to raise this claim earlier. The claim is already waived. So they're not saying, "Hey, we agree. There's no procedural bar." They're trying to have their cake and eat it too.
Yeah.
Saying, "Oh, well, you can, if you got a good
you can drop
reason,
all this and head for and head for this thing, which we hope you'll be barred from." So
it's Charlie Brown holding, Lucy holding the football for Charlie Brown. "Come on, Charlie, kick the thing." "No, you're going to pull that thing out from under me." "No, I won't. Come on, trust me. Trust me, Charlie. Trust me." Did Charlie Brown ever kick that football? I want to know. Did he? Did he ever make contact?
I don't
with the ball.
Recall that I've ever seen it.
All right, that's what I thought. Okay, bottom of 7. As with Avery's previous request, staying this appeal and remanding the case to the circuit court. Over to page 8, top of 8. Under these circumstances, would not address a specific issue related to the order Avery is appealing. Well, he's appealing multiple orders, but we'll put that aside.
Right.
But would instead be a remand for what? A new separate action. No, it's not a separate action. It's a new claim that could be easily consolidated with all the other constitutional claims. Next paragraph, they cite the cases. Tracy went through all these cases in the past, and again today, they don't say what the state says they say, and so they sure as heck don't say that a new constitutional claim can't be brought and remanded. It's just absolutely wrong. If you have good cause and the court wants to do it, it can be and shall be done. Next
and
paragraph.
remember, folks, the state's not talking about the bones here. They're not talking about any of the real issues of the motion. They're just trying to dance around about how procedure bars this from even being an issue. That's the way they want to argue it. So, like I said, just calling attention to that one more time, because I think it's interesting.
Page 8 of an 11-page motion. We've yet to hear, what they did with the bones. We've yet to hear anything about the preservation statute.
And whether or not they did inform Avery's counsel at the time when they gave him back, none of that. Zero.
Yeah. The last full paragraph on page 8, or the litigation of a new separate motion on entirely new grounds. I'm sorry. I think I had 6 margaritas at the place tonight.
Hey, no worries.
New grounds is not a specific issue related.
I think whoever wrote this motion might have had 6 margaritas at the place before they wrote this, because they keep repeating themselves.
Or 6 or 6 Starbucks, one or the other.
Right.
And is on entirely new grounds is not a specific issue related to the order Avery is appealing. Right. It is a new action, and a stay and remand is not appropriate. As noted, this appeal has been languishing for over a year.
Languishing.
Well, that's not what the statute says it requires. The statute is intended and designed, and that's why they have this motion to remand and add stuff, is so it's not done piecemeal in serial. And so point it out to the court, let them know, hey, found this out. What do y'all want to do? We think it makes more sense, do it all together. But all they've said so far is it's new. Okay, over to page 9.
And new, there's nothing that bars new, folks. Remember, nothing bars new.
You're not saying it right. It's new.
New. Okay. Nothing bars new.
I think I'm getting that from Monty Python.
I think you are.
The knees. It's new. Anyway, okay, let's stop being silly. This is serious business. Okay.
Hey, well, it is the state's response. That's why I'm not wearing a shirt and tie today. So, anyways.
Okay. Top of nine. All right. Filed. Avery's perpetual delay of this appeal by continually requesting remands to the circuit court to litigate new issues unrelated to the circuit court's denial of the motion at issue here must end. This aggression will not stand.
I love it. Yeah, okay. This whole thing does not go anywhere near the issues at hand, does it? Just continually tries to use the law to say that she shouldn't even be bringing it. Right?
Yeah, I'm wondering if this, AG, Tiffany Winter and Lisa Comfer, I wonder if they lock them up in their offices. You can't come out until this appeal is over. Sorry. I just don't understand. I think Meade protests this too much. Next paragraph. Okay, the silly nilly. Speaking of being, silly, If Avery no longer wishes to challenge the circuit court's decision, who said that?
Yeah.
And instead wishes to litigate a 97407 motion or a new
New.
06 motion, you may voluntarily dismiss this appeal. The process of winnowing out weaker appellate claims and focusing on those more likely to prevail is the hallmark of effective appellate advocacy. Well, if that sounds familiar, the Smith v. Murray case is because it's a exact, they just copied and pasted that exact paragraph into this response. Next paragraph, and it's absurd, it's utter nonsense. He's not going to dismiss his appeal. You know,
that's what I was saying in the beginning, when I feel like the state is trying to suggest that this is our only option because they see it being a good thing for them, obviously. But anyway.
Alternatively, if he does not wish to give up his challenge, he must wait until this appeal is resolved and then determine how he wishes to proceed. And again, what economic, judicial economies, you know, makes no sense to do that.
Right.
Either course of action would be appropriate. Yeah. Dismissing an appeal would be appropriate. Staying the appeal and remanding the case to the circuit court for fact finding on an issue wholly unrelated to the order being appealed, however, is not. Avery's continued attempts to hold this appeal in indefinite abeyance while he searches for new issues. He's not searching for new issues, Tiffany. He, through his counsel, is uncovering stuff your predecessors have tried to cover up or been afraid to supplement.
And now they've dumped it in your lap.
And now that, you know, it's in your lap. Boy, that's a great analogy. I'm sure if you ask this new attorney general, you notice
Josh
that
Call.
he's right on here now, and he's up
I noticed
there,
his
Joshua
signature.
Call.
I noticed him as well.
I'm sure he'll let you out of your office during the pendency of the appeal.
Right there, folks.
Why don't you reciprocate, let Stephen out during the pendency of the appeal.
Yeah, right.
And then, we'll all light a fire under Zellner. I'd be the first one. I'll get down in front of her building and start a picket, let's speed this along. What do you care, Tiffany? This appeal is an indefinite abeyance while he searches for new issues he did not raise before the circuit court. Whose fault is that?
Yeah. In this case, they withheld pages of queso. And she discovered that on the 24th and promptly filed a motion.
Not to mention they gave bones away that could, potentially
violation of a statute, which they didn't address.
Well, we still have 3 sentences left. Let's not rush it.
Okay.
Scroll up a little bit, page 10. You're already on the conclusion. You got to go up.
You were talking about Josh Call, so I went down and showed.
Yeah. Okay. Thank you. Okay. Go up just a little bit on page 10. 3 sentences. Go up.
Oops.
Keep going. There. Stop. Okay. So now I'm at the last sentence where it says his appeal is from the trial court's decision to deny his previous motions without a hearing. It is time for this appeal to move forward. Okay. Well, that's your opinion. That's your argument. Now we're to the next page, 11, the conclusion. How many times did you count the evidence preservation statute? Erekose?
I didn't.
0. Okay.
Yep.
How many times, other than mentioning what Kathleen Zellner's argument was in her motion, how much time did you send them spending on
The bones.
answering where these bones went, or
Right.
what they
None.
gave to the HAL box, or even that, hey, stop the bus, don't panic. That's not what we gave the HAL box. How much time did you see them spending on that?
Exactly. None. Zero. Goose egg.
So the conclusion, 97406 motion is not a specific issue related in the order Avery is appealing. It is a new and separate action in the circuit court. Well, there's nothing that prevents that in the statute that allows for remand. In an
New is not a problem.
unpublished, in an unpublished case, not a problem. None of the cases that they cite does it say you can't do it, because as they correctly point out in the law, relevant law, page 3, Avery is because you cannot mess around with the Court of Criminal Appeals. It is a violation of the bar provisions to falsely cite to a court a law. And so they say Avery is permitted to petition the court for remand to the circuit court pursuant to 808.0755. Page 3, relevant law. 5, I'm sorry. The 3 looked like a 5. I apologize. There
you go.
Avery is permitted to petition the court for remand to the circuit court for action upon specific issues pursuant to 808.075. The decision to remand is thus left to the court's discretion. That's it. That's the law. No cases say you can't do that. An unpublished case, the first district, which Tracy tells me is Milwaukee, they did it. It's happened before in this very case. They remanded. It took a whole 90 days, start to finish, to have the motions filed,
that issue
considered.
Combined.
Yep.
Right.
And now it's up on appeal with all of the rest, been consolidated.
Right.
What are they so afraid of? But that's all we need on the motion, unless you have anything else you want to point out on the motion.
I was getting ready to take it down.
Yeah.
Hello, I'm back. Hello, everybody. All right. Let's see what's going on here. What's the likelihood that the bones given to the hall box go missing when requested? Why does the state keep wasting paper? That's from Julie Johnston.
They're missing now. As you and Tracy have pointed out, but Tracy last night was mentioning that, in CASO, and your subscribers, know CASO well, and they know this part. In one part of CASO, but this return of the bones to the body, it sounds like they're returning the evidence tag numbers and all of the bones under those specific evidence tag numbers. And there's another part of CASO where they talk, that next page, and you're not really sure what they're returning. They're, separating bone material from not, and so you don't know. But
right,
we know some stuff was returned that was suspected human bone, and so we're not. I think there's zero chance of those bones that were returned to the hall box being available for testing because they've been returned, and we don't know. There's a break in the chain of custody. There's even if they were buried, that's going to create problems.
Right.
If they were cremated, there's not going to be anything. So that's the answer to that question. What was Julie's question?
Julie had said, let me see. First off, let me address, where'd she go? Sophia Alania. Yes, I will be doing videos in the future with Scooby. Been talking to Scooby the last couple of days. And so, yes, there will be more with Scooby in the future. And Jennifer Johnston.
That's a big thumbs up. I didn't even know that news. That's great news. How long are you going to hold on to that?
Well, I'm just been talking to her like we usually talk because we're friends,
Okay.
you know.
All right.
But you know,
I'm kidding. I'm kidding. It's like you're holding on to queso or something.
So, well, somebody was asking.
That's great news. Great news.
Why does the state keep wasting paper? Was her question.
Okay. I don't know, but I found out something today, Julie, through Tracy. Last night we were talking up until pretty late, just about boring legal stuff, about cases and holdings and all this weird stuff. But I said, hey, she said, yeah, I'm going to drive over around noon to pick up a copy of the state's response. Hopefully someone will have it before then. I didn't realize she drove over there. And I said, well, can't we, it's an hour and a half drive for her, except, when it's 20 below. And then, I said, I'll call a courier. Well, can't we call? I'll give them a credit card and we'll have them email to us. She said, no, they don't. They don't do that. Listen to this, Julie. You'll get a kick out of this because I know you know how clerks' offices work and how paperwork work. They will not do that. You have to go in person and give them exact change. They will either take cash, but it's got to be the exact change or a cashier's check. You call up ahead of time, how many copies, what's the charge. They tell you over the phone. You go get a cashier's check, and you go down to the clerk's office.
Oh my God!
I said, well, you can't do it over the phone. So I said, well, I'll call in the morning and hire a courier service, and I'll price what it'll be, and I don't care, if it's. Even if they charge $1 a page, it's 12 for the motion, probably, 50, 75 for a courier.
Right.
Avoid her having to drive in minus 20 degree weather. But fortunately, this is a shout out. Sorry, it's a long, convoluted thing, but English Dan and SS Camaro popped on there this morning, and one of them, England Dan, had found out a little bit earlier that it had been posted on Reddit. SS Camaro pulled it off of Reddit, downloaded it on yours. I emailed it to Tracy, and long story short, somebody got that up. Your crew found it. We didn't have to have Tracy driving in minus 20 degree weather. So that is a great thing. Thank you. I'm not sure what his screen name is in your YouTube, either one of them, but SS Camaro and England Dan, you know who you are on the Discord. Thank you very much. Really appreciate that. Okay, go ahead.
Let's see.
Oh, Scooby's here.
Yeah, Scooby's here now.
Oh, okay. Hey, Scooby. Where's your? It's the dogs here. I've been
Scooby
busy,
the dog. Yeah.
but I was so happy to hear from you. Love you. and I'll talk to you soon. See, that's when the dog talks. It sees, and he's got code words, pause, and
yeah,
all kinds of stuff. And
it's called Scooby speak. That's Scooby speak.
Yeah, and then sometimes he lets. Oh, is Capaldi in here?
Is he? I haven't seen
Yeah.
him.
He is.
There he is. What's up, Mr. Capaldi?
Hello, Mr. Capaldi. Much respect.
We must abide the dude. What's Charlotte talking
The dude
about?
abides.
The dude must abide. Okay. Let's see. Were the locations of the return bones documented? That is, did any of them come from the quarry where CX was found? And the answer to that is yes. The hip bone, the suspected hip bone, was found near the blood that gave the profile of CX. We'll never know. Are you mocking the defense attorney? Julie Johnson asked, were you mocking the defense attorney?
Yes, I apologize.
How much?
New. It's a new claim. A new claim. It's new. Yes, Julie, I was a little bit, but it's the only way I could get through it without throwing my laptop across the room. So please forgive me. No disrespect.
Okay, so
much.
Oh yeah, that's like give him a check in. Okay. Lady ran into Milwaukee musicians today. Oh, okay. Falcon. Just looking for a question here. So it looks like there's no more questions here. So let's see.
All right, let's just cover the procedure really quick.
I know, Rubber Ducky brought up here earlier, though, I saw where she was saying if she had to talk about this now, because if she didn't raise it now, as we've been saying, if she didn't raise it now, there's all the freaking possibility that the state would have been able to argue, well, you didn't raise it when you found out. So, you're screwed. And she's now taking that off the table. That can't happen now. So that's important. So, all right. Oh, question. Is there a reason for the time frame of releasing the bones in 2011? Why not release them in, say, 2008? I believe the timing on that, and here, I'll give my reasoning on that and then let Travis go on his. But basically, I feel like they felt like Stevens' appeals had just wrapped up. He'd just been denied by the Wisconsin Appeals Court. He was petitioning the Wisconsin Supreme Court. You get the feeling they knew that wasn't going to go anywhere. And so they wanted to start giving bones back to the Hall box type of thing. That's at least the way it looks to me, because the timing they chose to give them back is very interesting. However, Brendan, his appeals went in like 2013, so it was 2 years before he was done. So he should have been notified about that evidence. And I don't hear Drizzen and Nyrider talking about that they received correspondence that about those bones being given back to the Hall box. So,
Yeah, that good point. What my thoughts are on it is, they had the opportunity in this motion right here to answer some of those questions, but they didn't avail themselves of that. I don't know the answer to that question. Yeah. I could speculate about it forever. I know how to answer the question. I know how to answer all of those questions. Remand it, set it for a 3-day evidentiary hearing, and I guarantee you, Kathleen Zellner will get you the answers to all of those questions.
Right. Falcon, hey, bud. Look, Falcon Apata says, and have some measure of closure and get on with their lives, referring to the Hall box, referring to these bones being given back. Okay, I just want to say one thing here. The Hall box were given 40% of Teresa's bones Most
No,
likely.
No. They're given
Some part of what was in the burn pit.
8 item numbers. I mean, we went through those photos. We're talking.
What did they originally bury?
60 bone fragments.
Mm-hmm.
But they were,
Well, anyways, the point is they were given something to bury back
Yeah.
in whenever. They were given some portion of their family member, Teresa, to have a ceremony to do that whole deal with. So I don't understand why it's important in 2011 suddenly to go into an evidence locker and give bones that Ken Kratz said at trial he wouldn't spend 20 freaking seconds on. Okay, and to somehow in 2011 to decide that those bones are going to give the hall box some deeper measure of closure or whatever. I don't understand your logic there, Falcon. Basically, that's what I was getting at. So maybe they weren't given the 40%, but whatever, they got some part of Teresa originally that they had services and all that and paid their respects. So I really don't understand how giving them bones that Ken Kratz couldn't spend 20 seconds on gives them any deeper measure of, I don't see that, bud.
Give me the screen for 2 seconds.
Go ahead.
Okay, let's see. I got to go over here, and then I got to go up here, and then I got to click this thing, screen share. I got to share. I got to go over here. You'll have seen this before. This is the graphs we made.
Right.
In Erekose's motion on December 18th. We did a whole live on this when the Erekose wrecking crew discovered that bones she had asked for with regard to DNA testing had been given away to the hall box. And then according to her motion filed in January, a civilian pointed out to her that bones had been returned to the hall box. But here is what was returned to the hall box. 7411, calcined bones. Okay, so those are burned bones.
Mm-hmm.
Possible, and this is Eisenberg's description. Okay, keep that in mind. This isn't Zellner's description, Kratz's description. This is the state's expert. Her description. Calcined human bone frags, possible cut edges. There are photos of these bones attached to the motion filed by Zellner in December. If you really want to know what was given to the family, you can look, except we don't know if they gave all of 70. We don't know if they gave all of these numbers. 7412, human and non-human bone, non-biological, some bone, not calcined. That means not burned. 5 of 13 burned, calcined with cut edges. Most bone fragments are all cut bone fragments or human. No element ID. So we don't know if they went through the stuff. Okay, find stuff with the cuts on it. Those are all human, and that's what we'll return. We don't know. We're never going to know unless there's a hearing. Talk about putting Teresa Halbach at rest. You'd think, and I know that family wants to know, were they given animal bone? 7414, burned calcined human bone fragments. 74, how are you giving this away? This biological material that could be exculpatory or inculpatory. Human bone fragments. Human is calcined with one cut edge, 7416. 7419, cut burned human bone. 8675. This was huge in the trial. No question, these bones were significant in the trial.
Mm-hmm.
Possible human burn, cut pelvis. When you hear about the pelvic bones
Mm-hmm.
and Strain talking about multiple burn piles in the quarry and pelvic bones, number of fragments, 7. 4 calcined bone fragments of unknown origin. What did they give the Hall box? Did they give them 11 fragments? They give them 7 possible pelvic fragments. Those are the bones that Kratz said he wasn't going to spend 20 seconds on. So I don't know, for my money, if you want peace, but the answer is probably, they're never going to know, depending on what's been done with them. I was kind of hoping that the state would come in and say, hold it. There's actually more queso. We sent those to Whiting and they returned the box back because, I don't know what they're going to say. I don't know what the Halbachs are going to say. I don't know what Whiting Funeral Home is going to say. But you're never going to get the answer to those questions unless you have an evidentiary hearing.
Yeah, that's the thing that needs to happen, as I've been saying for a long time. So I just want to go back real quick to look for something here that somebody says.
Oh, chased Julie away. Saw it night, Julie. Good night, Julie. Thank you for tuning in. Yeah, I'm sorry it's run late.
Good night, Julie. So, let's see. It's okay.
Stacy's here. Hey, Stacy.
Sophia, I do think I answered your question earlier. I do remember you having a question about the law or something. I'm pretty sure I asked Travis, or we talked about it for a second. It might be that you might have missed it. Let's see. Tony Pertini says 4 were given to the Hall box. If one belongs to TH, it was found at the quarry, then everything about KK's murder scenario is out the door. Absolutely. I asked about the Fifth Amendment. Oh, I do remember something about Fifth Amendment.
Okay, there's 2 parts of the Fifth Amendment: the right to not testify against yourself, not incriminate yourself.
Right.
There's also a procedural due process under the Fifth Amendment. Most people refer to the Fifth Amendment as self-incrimination.
Right.
But not sure in what context they would mean. So you don't have to speak against yourself. They can't call you to stand. They couldn't call Brendan and force him to testify against Stephen. Couldn't force him. He could if he wanted to. If he'd made a deal, he could have. But they can't force him to, because it would mean incriminating himself potentially. And so you could take the Fifth. They can't force him to testify. They can't call a defendant to the stand in a trial. It would be a violation of the Fifth Amendment. And they can't comment about it to the jury before, during opening arguments, during jury selection. The defense can ask, my client doesn't testify, you're going to hold that against him. You're going to want him to testify. After voir dire, the state cannot mention. They're usually instructed that you're not to consider it if somebody talks about it in in jury deliberations. You're to tell them to stop talking about it immediately. If they continue, to call the bailiff, and the judge will handle it. So that's oral testimony against yourself.
Mm-hmm.
And then the question becomes, okay, well, do I have to give a DNA sample, a buccal swab?
Right.
That would be testimony against myself. Do I have to allow a photograph of my private anatomy because there's something distinctive about it that a victim might be able to identify? That would be testimony against myself. Those things don't work. They can collect samples from you. They can photograph you. They can't polygraph you without your consent. That's considered a statement. They can't take a statement without your consent. You have a lawyer there before you give any type of a statement. But if you do testify, you can be fully cross-examined by the state.
Right.
Maybe they're talking about Fifth Amendment that can Stephen testify in an evidentiary hearing. That's a little bit different. You can have your client testify in an evidentiary hearing on limited issues, and the state can only cross-examine your client on those limited.
On the limited scope. Oh, Travis froze.
Get a letter, Stephen.
There he is.
And no, I never got a letter saying they were going to destroy evidence.
Right.
And they could cross-examine about that. And well, didn't you get a letter? Here's a green card. Didn't you sign for this letter? Is that your signature? It's like, oops. Yeah, but that wasn't the letter that was in that envelope. It was this. They could talk about that, but they couldn't all of a sudden bring up, okay, now. Isn't it a fact on, such and such a day, you said this about the burned barrels or, no, it'd be limited to that issue. So I hope I answered whatever.
Well, she asks,
oh boy.
She's asking how long does that doc last?
How long does what last?
Yeah, that doc. I think she means documentary, maybe? I don't know. She's asking me to read the question, and the reason I didn't read the question is because I couldn't understand it. So
read it one more time.
Read it again, or do it again, please. Because first of all, you spelled long ling, so I'm thinking maybe there's other typos here.
Maybe she's asking how long I'll talk before shutting up. I don't know. I'm shutting up now.
Let's see. Not my question. Not your question. Okay.
Oh, okay. It's your question. Answer it, Erekose. Come on.
Well, I don't know. She's saying she wasn't talking about her question. She's talking about. I don't know. I have no idea.
Sophia?
He signed a Fifth Amendment doc. She's okay. So she's saying Stephen signed a document.
Okay.
I think.
Okay.
Saying he wanted a lawyer. Okay, so he was signing a document saying he wanted a lawyer.
Okay.
And
that is, so after you're arrested and charged, your right to an attorney is under the Fifth Amendment. Most people don't know that that's part of the Fifth Amendment. And you are entitled to an attorney through the trial process, and they either have to appoint you one if you can't afford one. In this case, he could afford one, and he hired them.
Well, at first he didn't have money to hire him, though.
No, that's what I said. At first he was appointed, and then he hired.
Well, she's saying he never got one. She's under the assumption he never got one. Is that true? I don't think that's true, right? They appointed somebody.
This is Stephen?
Yeah, I think she's talking about Stephen, I believe.
He had appointed attorneys through the preliminary hearing, and then that was in December of 2005. I'm not sure when the settlement was, but he hired Strang and Buting immediately after settling the case.
Right.
Now, maybe she means in one of these statements that he gave that were videotaped. It's been a long time since I've gone through those, but maybe he mentioned something about a lawyer in there. That wouldn't be your Fifth Amendment right to an attorney. It would be under Miranda, your 14th Amendment due process rights to an attorney. But you have to ask for one to trigger that. You have to say, I want an attorney. I don't want to answer any questions until I want an attorney. You keep answering questions, then you're not entitled to an attorney. But I'm not sure if, does anybody know, did Stephen hint around, hey, maybe I need an attorney on this? It has to be an unequivocal request. Yes, Sophia says yes. It should be an unequivocal request. You can't say, hey, you guys think I should have a lawyer here? And according to the Supreme Court of the United States, it's not good enough.
Yeah.
You have to say these words, read my lips. I want a lawyer. I want a lawyer. And there's no shame in doing that. But people get guilted into stuff all the time.
Okay, so Rubber Ducky's saying that at first they tried to establish that Stephen didn't qualify financially for an appointed lawyer, however. And then Sophie is saying he signed a document. Not sure what they're referring to. Guys, we're going to have to revisit this issue later when we've been able to research it, because you guys are talking about something that I just really can't.
Yeah.
I can't confirm or deny.
Yeah, here is the key. None of that really matters. You can sign whatever. They can say, no, you can afford one, blah, 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 blah. Here's what matters. Was he ever required to represent himself in a hearing? Was he ever questioned by anyone after he requested an attorney and they didn't give him one? The court can make a preliminary determination. Hey, you haven't shown me that you're indigent yet. You gotta fill this out and sign it. But until then, you're going to need to appear at your preliminary hearing by yourself. Mm-hmm. Unless something like that happens, there's nothing to really worry about. Happens all the time that people refuse to fill out forms, and I'm not going to fill out that form. Heck with you. And it's like, well, I can't appoint you one. But they end up appointing you one anyway. But he had attorneys at his preliminary hearing. He had, from what I could tell, at that point, he had counsel appointed to him and actively representing him up at that stage. There were multiple bail hearings, and it's been years since I've gone through all of those. I've read them all, but every one of them was responded to by an attorney. The only time I remember Stephen filing anything on his own behalf, he filed 2 crazy civil suits against Manitowoc County or Calumet County. I can't remember which one. One was because they took his Grand Am for testing, and he claims it had a full tank of gas, and when they returned it, it had an empty tank of gas or a half full tank. And so he was suing for 10 gallons at, $2.50 a gallon. I'm not kidding you. These are on StephenAveryCase.org. And he filed affidavits of indigency, so he did not have to pay court costs like filing fees and things like that. And the federal judge may have denied that. Said, no, I don't find you indigent, but that would have nothing to do with his criminal case. And then he was self-represented for that first 97406 motion. After he lost his direct appeal, he filed a 974-6 motion on his own that Kathleen Zellner ultimately determined was better to abandon and dismiss in order to go forward, because she knew she was never going to get anywhere with what she had. And then she filed the motion for new testing. And then after that was finished, she filed the motion for her own 974-06 motion for post-conviction relief.
All right. Okay, well, I think we've pretty thoroughly gone through all of this here today. What happened to my mouse? There it is. Let's see if there's any last questions here.
Need help for 10 minutes.
That's over on Discord. Yeah, they're talking. Not sure what that's all about. That worries me when I see something like that. Anyway.
Yeah, well, I wonder what the temp is where Stacy's at. Man, they're asking just wondering what the temp is there. I guess Stacy was on earlier.
Summary, please. Summary of what? Rebecca, what do you want a summary of?
Summary.
Well, thanks, Denise.
Okay, I'll summarize it. So everything she said in here is bullshit.
Everything the state said in there is BS. There you go. Summarized. Alrighty, so I think it's time for Stacy now. So
5 degrees Celsius. Man, well, that's not too bad. That's way over freezing by 5 degrees Celsius.
All right.
Minus 24 C. I don't know what that is in F.
Something going on.
Cold.
Freedom is in danger. Agents of the state, they taking children from the manger. Oh, they will sacrifice your kid. Take Brendan Dassey, that's exactly what they did. They needed someone, oh, Jody wouldn't flip. They looked around, saw him quick. Oh, it made so much sense why. Oh, Brendan Dassey, he was Stephen's alibi. There's something going on in Wisconsin that's not kosher. We better stop, let's all take a look closer. Oh, they will sacrifice your kid.
Take Brendan Dassey, that's exactly what they did.
They visit him once, they visit him twice. They make him feel so safe. Sandwiches, soda, so nice. No cameras rolling and under no lights. Who knows what went on up in Fox Hills Monday night? There's something going on. Freedom is in danger. Everything about this kid getting stranger and stranger.
Oh no, they will sacrifice your kid. Take Brendan Dassey, that's exactly what they did. March 1st,
alone in
a room with Bert and Ernie. No parent present and no attorney. 4 hours later, with a touch of the knee, they finally get Brendan to agree. Something going on. I said there's something going on. They will sacrifice your kid. Take Brendan Dassey. That's exactly what they did.
There's something going on. I said freedom is in danger when the
Agents of the state, they're taking children from the manger. Oh, they will sacrifice your kid. Take Brendan Dassey. That's exactly what they did.
Take Brendan Dassey. Oh, that's exactly what they did. Get on the train before it leaves the station. Wisconsin versus Avery, a complete fabrication. Get on the train before it leaves town. The truth train coming, gonna run them down, run them down. And we all know Stephen and Brendan were framed, but it does not take a brain surgeon to see that they were framed. Yes, we know what this was about. The civil suit settlement they did not want to pay out,
Oh, thank you very much, Denise. That's very kind.
Oh, maybe you don't get it.
I suggest you look up TikTok, Man-It-To-Walk on Reddit.
You will
Find trial transcripts, evidence files, and reports.
and you start to fathom
The corruption within the courts.
Now as you shake your head because everything seems amended, you will
You'll find yourself in the company of 3 on-bank judges that dissented.
But
Don't you worry, you're not going insane. You're just having to sit down on Zellner's truth train. Get on the train.
I said before it leaves the station,
Final destination, inevitable exoneration. Get on the train. Before it leaves town, the truth train coming, gonna run them down, run them down.
Get
Get on the train. All right, one more, folks. And I love this one, especially the Barn Studio version. Oh, they say you can trust us. Oh, but they use the badge for an illusion of justice. Oh, they say you can trust us. Oh, but they use the flag for an illusion of justice.
It's
indefensible. Oh, now what they did. Convict an innocent man twice with a 16-year-old kid. We can't turn away, pretending all the pieces fit. Oh, but if we turn away, we let them get away with it. Oh, they say you can trust us. Oh, but they use the badge for an illusion of justice. Oh, they say you can trust us. Oh, but they use the flag for an illusion of justice. Oh, justice. Justice. We need a wrecking crew to tear this whole thing down. Oh, did you hear the news? There's a new sheriff in town, not that need touching one, not the one supported by them clowns, the superhero one. She's gonna tear their house of cards down. Oh, they say you can trust her. Oh, but they use the bag for an illusion of justice. Oh, they say you can trust her. Oh, but they abuse the bag for an illusion of justice. Oh, justice. Justice. We need a wrecking crew to tear this whole thing down. We're going to go one more. I'm going to go one more. This one here. Thank you very much, Denise. Thank you very much, everybody, for tuning in. Travis and I do a lot of work behind the scenes to try to be able to bring this stuff to you guys. It's great that you all show up. You guys all rock, and thank you.
Wisconsin can be so cold.
The scales of justice can erode. If we accept life's big and bold, or we forget we live on Avery Road. We live on Avery Road.
Should be
easy to see. This could be you, could be me. We can't sit by idly, accepting everything that we are told. I live on Avery Road. I live on Avery Road. I live on Avery Road. One more, guys. All right, una más. Last one, because I love this one so much.
Around about the law enforcement, a right bunch of clowns.
No, YouTube. All right, folks. So that's about it for today. As usual, if you haven't already, please hit subscribe. We'll see you.